Are we able to use artificial intelligence to design a blurb for our book and still have our book protected? It depends on how you are doing this and the manner in which you're using it. So we're talking to everybody's favorite IP and entertainment lawyer to find out more. And make sure you check out our previous videos on why you can't use AI to write your novels and have it copyright protected.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
When it comes to AI-generated content in the publishing world, are we going to be able to use AI-generated blurbs for our books? This can be on the backs of our books, on Amazon and Barnes & Noble, in our marketing. What does that look like, Tony?
So we'll obviously start with what we've talked about before, which is that the general position that the U.S. Copyright Office has taken is that anything AI generated is not worthy of copyright protection. So whether that's AI generated text, movies, pictures, artwork, anything else, that's not worthy of copyright protection. And the rationale from the Copyright Office, at least from the decisions that have come out from their appeals board, is that anything that is generated using artificial intelligence lacks human authorship. And according to the Copyright Office, to receive a copyright protection or copyright registration, rather, you need to have substantial human involvement. What's interesting, though, is that the Copyright Act of 1976, neither the Copyright Act of 1976, nor the Copyright Act of 1909, nor the Copyright Act of 1830, nor the Copyright Act of 1790, no iteration of any Copyright Act that has ever existed in the history of the U.S. has ever made an explicit reference about the human authorship requirement. It is not explicitly written to in any way, shape, or form. The essence of any reference to human authorship is in maybe Article 1, Section 1, Clause 8 of the U.S. Constitution that lays out kind of the basic principles of intellectual property and protection. And it does make reference to living beings. So, or naturalized beings, I think is the more accurate terminology, if I'm not mistaken. But that's like the only extent of any reference to a human author that's made reference to explicitly in the law related to IP. The only other guidance we've had is really from case law, and there are two seminal cases that came out in the Supreme Court in 1879 and in 1883, if I'm not mistaken. The more senior one being the trademark cases that came out of the Supreme Court that, ironically, is not even a trademark case, it's more of a copyright case, but it does lay out that substantial human involvement is a necessity to have a copyrighted work. We've seen later case law kind of reinforce this point, the most well-known one being the Naruto v. Slater case, which is the monkey selfie case where the monkey took a selfie of themselves. And in that case, PETA was arguing, well, this monkey should be afforded rights under copyright law. And yes, while the monkey did make an original work of authorship by touching the shutter and capturing that camera, that image of himself on that camera, the problem is that monkey can't contemplate his rights. He doesn't know when someone else infringes on his work. He doesn't know how to license out his work to somebody else to make a derivative work out of it. He can't pursue a copyright infringement claim against someone that infringes his work. So for all those reasons, while he makes a copyrighted work, he cannot himself enforce those rights. Thus, he cannot be the registrant on the U.S. Copyright Office registration for that specific photo. So all that to say, that's been our guidance, even up to current day, related to human authorship. That said, when you talk about it in the context of a blurb in the book, now this brings up, again, a pretty paramount question, which is the Copyright Office going to say, oh, we're going to only provide protection to the entirety of the book except this blurb that was generated with AI? Or are they going to say, well, this blurb was generated with AI, but the rest of the work was created using substantial human involvement? We'll let this fly. We have yet to really get any guidance on that point. We don't have any guidance from our legislature on the federal level regarding AI to begin with. We have no other guidance from the U.S. Copyright Office on this point alone. And I think that this adds a very unique wrinkle. But I guess my guidance to anybody that is watching this video, if you do use artificial intelligence to generate a blurb for the back of your book, or let's say to generate a summary in the inside cover or what have you, when you register that book in the U.S. Copyright Office, you should still disclaim that you use that blurb, that you created that blurb using artificial intelligence. And it's worthwhile just finding out from the Copyright Office if that element will still be protectable or not. And if they say, no, it can't be protected, fine. At least the rest of your book is protected. That's the most important thing of all. You spend your hard-earned time, energy, you sweat blood, sweat, and tears to make that book possible. At least you know that you can sleep at night with the peace of mind that you got a copyright registration for the book itself. But if you do get it, at least now we know, okay, you write a blurb on AI using AI software, you register that and incorporating it in the general book itself. All the rest of the book you wrote all on your own, and you get a registration number for it. Great, then we know that U.S. Copyright Office does take seriously the substantial human involvement aspect of things, so it'll work out. So it's very hard to say, but I think with the guidance that we have so far, those are the best answers that I think we have on this specific subject matter.
So with that in mind, we can use AI to create those blurbs, but it's not necessarily something that we want to include in our books if we want to make sure we've got that copyright protection. It may be better to do it on our own. Do you feel like there's a difference between putting it inside of our books and then just keeping it on the marketing platforms where we're distributing our books, like Amazon's blurb where we're writing that out, but not as a part of the book?
I mean, I guess that's a great point. And I guess what makes that scenario possible is now you're going to get definitely a guaranteed copyright registration for just the book. If you exclude the blurb and just use the blurb on a marketing website, or like on your own actual website, or as like the synopsis on Amazon or Barnes & Noble or wherever you sell your book, that I think functions well. And you're not really going to have any sort of lingering copyright issues floating over your head at that point. I think the essence of using AI generated blurbs on websites is more or less to draw the reader. You're not really trying to legally protect the blurb, because I think what's more worthy of legal protection is the entirety of the book that you invested time, effort, and money to make possible. So I would say that if you want to include the blurb as part of your manuscript and use that as the work of authorship that you're registering in the U.S. Copyright Office, again, it's worthwhile to make that disclaimer to the Copyright Office and say, everything was created by me except this blurb that's located in page 500 or whatever. And you could disclaim that it was generated using ChatGPT or another AI software. And it's worthwhile just to see what's the Copyright Office going to say. Are they going to view that aspect of the entire manuscript as not worthy of copyright protection? So will they tell you the book will get copyright protection, but not the blurb? Or will they tell you the entirety of the manuscript, including the blurb, will get copyright protection? This is actually, the kind of thing that I think someone will eventually try to do, and we'll get new, policy or new law out of this. So, if somebody is watching this and wants to give it a crack at it, great, please do, because this law professor is scrambling to find new material to teach on. So, I think it's worthwhile.
And speaking of these upcoming developments, before you get into my comment section and tell me new things have happened, check the date of this video and all of the videos that we are making to see if we have updates, because we frequently tell you as breaking news is happening inside of this space so that you are as up to date as possible on what's going on and where you are and are not legally protected. And if you have questions for Tony on these topics, drop them down below. He's coming back for upcoming episodes, and we want to make sure we're getting your questions addressed. And as always, you can hang out with Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
If you have questions on this, go ahead and drop those down below. Tony's coming back for upcoming episodes, and we keep breaking news in the world of AI content generation and how we can and cannot be leveraging it in the publishing world to make sure you and your work is legally protected. We're going to give you some tips, some tricks, some ideas for how you can be effectively using it and what to stay away from right now. And as the court cases continue to roll out, we'll be bringing you that information as well. Drop your questions for Tony down below, or drop your questions about writing, publishing, marketing your books here for our daily episodes, so we help you navigate the world of publishing so that this can be your most profitable year ever. We'll see you in the upcoming episodes.